When a date is fixed by a judicial order, appropriate
It had not been
petition.
taken up earlier, Lordship, in the last 2 days. So I think there are no any judicial order.
Your thought will not change my thought.
Applied.
I am a clear from the list. So item 43 is a high school matter. Some 16th and have heard similar matter, batch matter, and posted date for 16th of June. If it could be either that or it
No, we will pass the order as and when the case is called out.
डेली दिस सीआर नंबर 23 मिला
अगर टेकअप नहीं हो तो उनका 16 जून को करें।
सीआर नंबर 23 मिला ऑल ग्रीवांस ऑफ द सेम कुड बी लाइक फाइल द काउंटर
16 जून को तो कोई डेट नहीं पड़ा होगा। 16 जून
कब था वो? 16 या 19 जून?
16th of June.
केस का नंबर बताइए।
582
नहीं 19
वो 19 जून पर
2023.
19
19
सीआर नंबर 23 मिला डेली लिस्ट मिला द ग्रीवांस ऑफ द हर विल फुलफिल by file the counterfeit miला statement has been amount has been deposited in bank account of the person in this case we will dispute
कम एट 11 o'clock 11 बजे अदर साइड को लेके आए।
Let's see from the list you let's see serial number 56. The JPC was directed to file counter, but for the last 3 months they have not filed it. Illegal termination matter.
Contractual appointment.
Yes, yes.
They have not filed their contract. कल के लिए करिए।
56
Lordship, item number 22, Lordship. This is appointment of Vice Chancellor in 4 universities. During pendency of the present application, fresh advertisement were issued to the floated in Lordship, and during pendency, without taking permission, prior permission of the Honorable Court, they are proceeding arbitrarily.
Was there any order
Lordship,
that prior permission is required to be taken?
It is not a.
There is no urgency.
Lordship, the second half mechanism.
from supplementary list for orders item 1 WPS 4140 of 2023.
WPS number 4140 of 2023, Council for the petitioner submits that the present petition has become infructuous and therefore he seeks to withdraw this petition. Nobody appears on behalf of the respondents. However, considering the submissions, this petition is dismissed as withdrawn.
sign
Item 2 WPL 3336 of 2023.
The notice has been delivered yesterday. Okay, delivered. WPL number 3336 of 2023. इसका ऑफिस नोट फ्रेश बनाया है? ठीक। As per latest office note, the notice has been served upon the sole respondent. However, nobody has entered appearance on behalf of the sole respondent. Owes this case on what is the matter?
It relates to we have challenged the order passed by the learned presiding officer of the Labour Code under section 33C, wherein we have been directed to pay 50% back wages to the respondent.
What is your point? What is your main point?
Your Lordship, it is related to age. There was
Do we need the records?
yes.
Let the records be called for from the concerned court. Pose this case under the heading for final disposal on tenth of July. Parties to file short synopsis list of dates and the judgments Mr. Secret.
Permission item 3 WPL 4272 of 2021.
No advance notice was given. I spent half an hour reading this file.
On last occasion in this case, notice was issued and already served, but he has not appeared here.
It doesn't make any difference. How does that make a difference? He doesn't want to appear.
But my friend had to क्योंकि अभी वो आउट ऑफ स्टेशन है इसलिए
कौन आउट ऑफ स्टेशन?
मनोज कुमार का मिस्टर मनोज कुमार
एडवांस नोटिस को क्यों नहीं देते हैं जजमेंट? वेयर इज द रिलेटेड मैटर?
डेली कॉल इसमें सीरियल नंबर 8
मिस्टर मेहता appears? उनको बुलाइए. मिस्टर मेहता को बुलाइए. हाँ,
सीरियल नंबर 8 में है डेली कॉल.
हाँ, उनको उनके सामने ही एडजर्न करेंगे.
लेकिन हमारा ताकि नहीं है आखिर मान लिया अगर सुनेंगे तो हम लोग पूरा तो प्रोसेस नहीं कर पाएंगे.
आप वैसे भी एक दिन में नहीं कर पाएंगे, इसलिए जो बहस होगा थोड़ा सुनिएगा, राइट?
बहस तो उन्हीं को करना है.
डेली के अटेंडेंट के साथ
मनोज कुमार ने करेंगे, हम नहीं. हाइपर इंटरेक्शन मार्च सुनने जजमेंट
एडजर्नमेंट रिजेक्टेड, राइट? इसीलिए आने दीजिए मिस्टर मेहता को, हम अपने से एडजर्न कर देंगे. इतना इंसिस्ट मत करिए. उनके सामने एडजर्न करेंगे. बोथ द मैटर्स आर टू बी हर्ड टुगेदर. नहीं तो नेक्स्ट डे में यही होगा कि आई डू नॉट नो एंड यू डू नॉट नो. वी डोंट वांट ऑल दिस, राइट?
डेली से
हाँ, दिल्ली के साथ कॉल करेंगे. वो आएंगे मिस्टर मेहता, उनके साथ ही कॉल करेंगे.
अच्छा
Item 4, WPS 49 of 2023.
I have 5 minutes required to counter find the respondent of the last 5 minutes. Prior to that, my lord has ordered to make payment to respondent number 3, that is Manrega Commission, to deny to make payment. But district administration has made payment in part. As far as matter of honorary of petitioners are concerned, that was 14,800 per month on May 22. That has been paid in accordance with previous honorarium 10,500 per month. So far as matter of merit is concerned, kindly have a look to some points which deserves to be considered by my lords. Some my lords very kind consideration. Admittedly, the petitioners were appointed by.
How many petitioners are there?
11 petitioners are there.
What is the date of their appointment?
Their appointment date is on in the year 2007.
And where is their appointment letter?
Yes, sirs. Kindly have a look to annexer 1 of main writ petitions. 1 of main writ petition, they have been appointed. While annexer 1 of main writ petition against advertisement which is at annexer 2 of main writ petition. Annexer 1 at page 17. Upayukt Karyalay Chatra, respondent number 5. They have been appointed by District Administration Chatra in the year 2007. While an order contained in memo 1338 Gopaniya dated 8/11/2007 against advertisement number 1967, which is at annexer 2, page 19 of main writ petition.
One of advertisement number 1 of.
Against advertisement which is at annexer 2 of main writ petition. Advertisement was also published by EC Chatra, District Administration Chatra, who is respondent number 5 here in writ petition.
Place the advertisement.
Yes, ma'am. Annexer 2, page 19
Yes.
of main writ petition. जिला ग्रामीण विकास अभिकरण चतरा जिला नरेगा योजना अंतर्गत एवं अन्य विकास शिक्षा स्वास्थ्य विभाग में कार्य हेतु संविदा के आधार पर कंप्यूटर ऑपरेटर के लिए पुनर्निर्माण हेतु आवेदन आमंत्रित किया जाता है. इसके लिए आवेदक की योग्यता निम्न प्रकार होनी चाहिए. शैक्षणिक योग्यता स्नातक, तकनीकी योग्यता BCA मान्यता प्राप्त कंप्यूटर इंस्टीट्यूट से कम 1 वर्ष का डिप्लोमा. आवेदकों को अंतर्शिक्षा एवं कंप्यूटर ज्ञान परीक्षा हेतु दिनांक 7 अक्टूबर 7 को जिला NIC ऑफिस चतरा में उपस्थित होना होगा. शॉर्ट हैंड का ज्ञान रखने वालों को अतिरिक्त अधिभार दिया जाएगा. आवेदक का उम्र 1/10/7 को न्यूनतम 18 वर्ष, अधिकतम सामान्य वर्ग में 35 वर्ष, अत्यंत पिछड़ा वर्ग में 37 वर्ष, सामान्य अत्यंत पिछड़ा वर्ग महिला में 38 वर्ष के बीच होना चाहिए। आवेदक अपने बायोडाटा एवं सभी शैक्षणिक प्रमाण पत्र छात्र के साथ अंतर्विक्षा कर तिथि को उपस्थित रहे।
You place annexure 1.
हाँ, annexure 1 मिनट्स। जिला स्तर पर कंप्यूटर ऑपरेटर के लिए तैयार किए गए पैनल सूची में से निम्नलिखित कंप्यूटर ऑपरेटरों को उनके नाम के सामने अंकित स्थान पर दिनांक 20/11/7 तक योगदान देने हेतु आदेश दिया जाता है। वे निर्धारित तिथि तक अपना योगदान देकर अनुपालन प्रतिवेदन हस्ताक्षरी को देंगे। हस्ताक्षरी डीसी चल रहा है। Subsequent to that minutes, they continuously worked up to May 2022. All of a sudden, their honorarium has been stopped. Subsequent to that, this petition was filed by the petitioners with 2 prayer signals. Firstly, with regard to payment of honorarium, which was due on the date of filing, and subsequent to that, their regularization.
Manreka. Yes.
Yes, minutes. After filing this writ petition, respondent authorities had filed counter affidavit at first occasion. They have not denied our even any of single averment minutes. Subsequent to that, a specific counter affidavit was filed by them. Thereafter, my lord has ordered to make payment. Thereafter, district administration Chatra has made payment in part minutes.
At what rate?
Yes, minutes.
At what rate has he made payment?
10,500 per month, whereas it should be paid at the rate of 14,800 with effect from May 22.
According to you, the rate is
14,800 minutes.
800 with effect from?
With effect from May 22.
They have made you payment till up to date payment they have done.
Yes, minutes. Up to date payment they have done.
Till May 22, they have paid you correctly? Till
Yes,
May 22?
Yes, yes, minutes.
You have grievance thereafter?
Thereafter, minutes. For same minutes, can we have a look to an excerpt?
No, you forget about it. That is a quantum.
Yes,
that
yes.
will be taken care
Yes,
of.
yes.
What is your main relief?
Yes, minutes. My humble submission notes for my
You have been
lord's.
discontinued.
Yes, minutes. No. After
When?
my lord's order, we all have been immediately removed from our service. Minutes. You are not required to do work. Minutes.
Where do you
After last order passed by my lords, wherein it was directed to make payment immediately. Minutes. Subsequent to that.
Where have you stated that you have been discontinued?
Yes, minutes. In rejoinder to counter, minutes. Rejoinder to counter.
Where have you mentioned?
Yes, no, sir. Yes.
Did you participate in the new selection process?
No, minutes. This is as because minutes. We have filed when the post of computer assistant was advertised minutes by the respondents. We have filed an interrogatory application.
First, let us show, please show from your rejoinder that you have been discontinued.
Yes, yes, minutes. I'm showing minutes. Yes, minutes. At para 9 minutes. That it is further submitted and stated that the petitioner had joined in the year 2007 and were continuously working up till now. When this honorable court has been pleased to pass an order to make payment of due honorarium to all 8 petitioners, then only it has been declared by the respondent authorities that service of petitioner is not being taken and their all due has been paid. Whereas in fact all 8 petitioners have worked till last order passed by this honorable court by an order dated 2nd of April 2020.
Yes.
Now let's kindly have a look to para 10 of my rejoinder minutes. When the post of computer assistant was advertised by the respondent authority minutes, we have filed an interlocutory application for modification in prayer minutes. In that minutes,
You were working as computer operator.
operator minutes,
Okay.
and post was advertised for computer assistant. And now they are saying that the post of computer assistant is under Manrega scheme, whereas there is no such post of computer operator under Manrega scheme after 17 years of taking our services. Minutes.
Is there any post of computer operator under Manrega?
No, yes, post of computer operator is not there under Manrega.
But you have been working as computer operator.
Operator was continuously uninterrupted since 2007 years.
So you cannot say that you were working under any vacant sanction post of computer operator.
Yes, minutes. Now, after rendering our 17 continuous year services minutes, they are saying that post was not sanctioned. Although post was advertised by DC Chandra, appointment has been made by.
So therefore I am asking, was it a sanctioned post? If DC has committed some wrong,
Yes,
so you will have a premium on that.
No, minutes.
Therefore I want to know from you, was there any sanctioned post for computer operator?
Yes, minutes. Kindly consider one thing, minutes. If DC has committed an error 17 years back, so for that, minutes, petitioner should not suffer. That is why.
Contractual employment.
Yes,
We
minutes.
cannot forget this term
Yes, minutes.
while considering your regularization.
Yes, minutes. Kindly consider one thing, minutes. When we find
He has maybe that he advertised it, but for whatever work you have done, you have been paid for that. It is not that you have not been paid for that.
yes, minutes after order of my lords. Minutes.
Whatever,
Yes, minutes.
they have paid it.
Yes, minutes. Now let's kindly consider one thing, minutes. Kindly have a look to annexure 1 of my main writ petitioners. 3 persons are there. 3 persons are there, minutes.
What do you want from the court?
Minutes. By way of last submission, minutes, I have a claim of law parity, minutes. From same list, 3 persons have been adjusted somewhere else. Kindly have a look to annexure 1 minutes of my main writ petition at page 17.
Page 17.
17 minutes. At serial number 5, Yasin Anwar is there, selected from same list.
Serial number?
Serial number 5 minutes.
Yes.
Yasin Anwar. At serial number 6, Sushil Kumar.
Yes.
And subsequent to that, minutes at next page 18, at serial number 21, Muhammad Marghub Alam.
Yes.
Now, minutes, kindly have a look to annexure of my rejoinder, minutes.
You bring something new in the rejoinder.
No, minutes, nothing new.
Okay. Have you stated so in your main writ petition also that there have been some relief have been granted to them?
No, minutes, they have filed specific counter affidavit. Rejoinder to that, we have bring all these evidence on record, minutes. Is that they are doing discrimination.
So you want an order without giving them opportunity to respond to whatever you have stated in
No,
rejoinder for
they
them.
must have an opportunity to respond.
Then why have you started your argument? Because the moment you bring something new in the rejoinder, you should have said outright that they need to respond to it.
For that, minutes, I apologize, minutes. I started, minutes, whenever the case was called, minutes, I thought, minutes, that my lords want to hear the matter, that is why I
This
was
is the
present.
habit, you see, if you want to bring anything new,
Yes,
you have to
ma'am.
file a supplementary affidavit so that they have an opportunity to respond.
So let them respond us. Can you play?
So you have wasted 10 minutes of the court, isn't it?
I apologize for the same notes, but it was not deliberate and intentional notes.
You do
Sorry,
not know
miss.
the procedure, we can't help it. You can't bring anything new in the rejoinder for the first time.
No, miss. They are.
And then you expect the court to pass an order on that.
No, miss. I am again sorry, miss. I again apologize, miss. But so far as matter of discrimination done by the respondent or
If they have done some illegality, they will
Yes.
rectify it.
Yes,
That
miss.
will not give you a premium on that. They have been regularized.
No, miss. But they have been adjusted somewhere else and they are still working at the rate of 14,800 per month.
Adjusted as computer operator.
Yes, miss.
Where is that?
Kindly have a look to page 20 minutes.
20 of?
20 of my rejoinder minutes. Yasin Anwar is at serial number 2, Sushil Kumar is at serial number 3, and Mahbub Alam is at serial number 4. All those have been appointed,
This
adjusted.
happened in 2017. When did it happen?
Recommendation was made in the year 17 minutes.
Then
No,
you
minutes.
had no grievance since 2017.
No, minutes. We were working continuously and
We
getting
do not
already
know
that
a decision which was taken in 2017. You had no grievance because you were working here.
is, yes, miss, we were
Then-
working, that is why we had no grievance.
Yes.
But now, milords, from
So
the
you
same
cannot
list-
say, you see, they have given some appointments. They have adjusted, given the work at different places.
Yes,
Way back in 2017, you were allocated this place. They were allocated somewhere else,
Yes, miss.
right?
Yes, miss.
There was no grievance. They were also being paid, and you were also being paid, right? Okay.
But
Till
yeah,
2022, you had no grievance.
no,
Now
miss.
you want to say now you claim parity.
No, miss. As because just we are getting honorarium, that is why we had no grievance. Now, milords, from the same
That
list.
will not give you any. That will not cut any ice. बताइए और क्या बोलना है? 2017 का ऑर्डर को अभी आप चैलेंज भी नहीं किए, कुछ भी नहीं किए.
उसी
Don't
लिस्ट
bother
से
about it.
उसी लिस्ट से उसी
How
तीनों
does
को-
that make a difference? From the same list, different persons were allocated, they were placed differently from one place to another. You had no grievance in 2017.
3 persons have been picked, milords, on pick and choose method, and they have been adjusted somewhere else. We are working, that is why we had no grievance. But at present, milords, we
We don't have anything to say on that. They have been regularized? No. They are working as computer operator only. Right?
Yes, miss. Listeners, let them clarify notes on these pointers. So far as matter of my law parity is concerned, Mr. Prem on that. Miss. From same list, 3 persons were picked and adjusted somewhere else, whereas other persons have been ousted. On what ground these 3 persons have been adjusted? They have been appointed since long back in the year 2007 from same list.
You have taken a decision by indicating that they were working since 2009. You were working since 2007.
7 years.
Under what provision have you taken this decision in 2017?
Under I take instruction of counter
It is an order of absorption or regularization?
No, absorption. Samayoj.
Absorption.
Absorption.
The learned counsel for the parties are present. The learned counsel for the petitioners has submitted that out of the select list to which the petitioner was selected as computer operator to work under Manrega way back as on 8/11/2007, 3 persons at serial number 5, 6
And
and
21.
21 of the list contained in Annexure 1 have been absorbed by virtue of decision dated 29/7/2017. As computer operator cum clerk in finance department of district administration. The learned counsel submits that the petitioner be also granted the same relief, and therefore it appears that the respondents have applied the scheme for regularization for computer operators who were appointed on contractual basis along with the petitioner. किससे आप मांगेंगे? At this, counsel for the petitioner, counsel for the respondent submit that he shall seek instructions and file a supplementary counter affidavit. The counsel for the respondents is directed to seek instructions from respondent number 2 to 6 and file a supplementary counter affidavit to be sworn by respondent number 2 or respondent number 3. एक्सप्लेन करिए भाई, आप मनरेगा को रेगुलराइजेशन दे रहे हैं, सबको दीजिए. Give it to everybody. Regularize all of them. And so you have to do it for everybody, right? अपने मन से 2 आदमी को पिकअप करके नहीं कर सकते हैं. बताइए कब तक करके बताइए. Tell us. Let the supplementary counter affidavit be filed by. Date बताइए कब तक करेंगे.
Within 4 weeks.
4 weeks you need for this. It is so simple.
Election time is
By 11th June file कर देंगे. Post on 12th June in the supplementary cause list. Let this case be treated as part of.
Item 5, WPS 2397 of 2023, along with item 6 to 30.
In this case, counter affidavit has been filed by the respondent number 4 just yesterday, and its copy has not been served to us despite the specific direction by para 7 of the last day order. The copy has not been served to us. However, the learned counsel of the read 2395 has given its copy on WhatsApp just now. Therefore, I am
No,
seeking
The
some kind of.
copy has not been served to us, is not a correct estimate, it has been served to some of the persons because 10 petitions are there, so 1 or 2 persons have not been served.
I am decision number 1 and I have.
Photocopy is to be given to them of the main case.
आप लोग को तो कल पता था ना कि आज टाइम लेने वाले हैं, पता था कि नहीं पता था? You knew that you are going to seek time today?
No, हमको नहीं.
Then you argue. आपको नहीं पता था, you argue your case. Please argue your case. Let me see what is your case.
The copy is also not served to us, Manoj. I am appearing in item number 11.
And several new facts have been brought forth.
If I have to pass an order in your favor, do I need to hear you?
No.
Not
So
at
let
all.
us see what is his case. Yes, what is
Yes,
your
yes.
case?
Manoj, may proceed.
As per the advertisement, you had given a particular pay scale,
Great.
grade pay. How can you withdraw that? Under what provision of law?
Yes, on the basis of the recommendation of the Fitment Committee, I have stated every.
No, how can you rectify it? They have acted pursuant to your advertisement. How do you rectify that? What is your response to this? Was it a mistake? You don't say that it was your mistake. Tell us.
My lord, the advertisement was issued by the Agriculture Department, which are not in consonance with the
You
Finance
should have
Department.
cancelled the advertisement and cancelled the entire selection process. You cannot advertise, give a particular pay scale in the advertisement, and subsequently say that this pay scale is not payable to you. How can you do this? Yes? Show me some provision of law, show me some judgment that it has been ever done, that you advertise the post, and then you say that no, this pay scale we will not give you. Yes?
My lord, the Finance Department has tried to justify it in the.
In what manner have they justified? What is your stand?
The
Tell us.
main stand is that the matter, the Fitment Committee recommendation, that after 6/16, those who are working will be getting 2400 grade, and new recruit will get 2000 grade. And there is a question whether how the earlier persons who are earlier appointed will get 24 and subsequently appointed will get lesser grade. That was also justified. That earlier the educational qualification was diploma, subsequently it was reduced.
You see,
10 plus two.
you can't change the advertisement. That amounts to changing the advertisement itself. How can you do this? Show me some precedence, show me some law that this can be done.
That the conditions.
No, you can't. You just tell us. If you were such kind of recruitment would have been done in a private player, then you would have your labor commissioner must have taken a good lesson. What happens to the government if they behave in this manner? Everything is weighted prior to advertisement, right? All concurrences, all required clearances are taken. And then an advertisement is published. People participate. You pay also for some time. They paid also for some time.
Always, since appointment.
Yes. And then you suddenly reduce the pay scale.
Now the finance said they have not reduced.
Finance तो बोलेगा कि बंद ही कर दीजिए, recovery नहीं कर रहे हैं. Have they asked for recovery also?
Yes.
Order has been passed, but nothing has been recovered.
You are waiting for the court. Order has been passed, but nothing has been recovered. What does that mean? Why did you at all pass the order itself? One fine morning, you will get up and then say that the pay scale was wrongly mentioned in the advertisement. Acceptable to you as a council? You just tell us. You forget about the state. Is it acceptable to you as a council? Think of another situation. State has fixed your remuneration. Suddenly they say no, it is wrongly fixed. So there has to be a recovery. Acceptable? When it comes to violation of terms of advertisement, and you say that the person did not have the required qualification, you say that the appointment is void ab initio.
That
It happens, no? That the appointment is void ab initio.
yes.
He did not have the requisite qualification. Right? Then your action is not void ab initio. You can't justify such an action.
Since the department will advertise the post and advertise the post and pay scale, grade pay, everything. In their counter evidence, they said that on the basis of the finance department guideline, we are now rectifying it. So your lordship has directed the finance department to file it. Finance department, the main contention is this, that in 660, resolution number 660, there is a clear stipulation that the person, the new recruit will get 32 to 4900 and their get pay is 2000. Then the fitment, that is on the basis of the fitment committee recommendation. The people approached before the appellate committee. And fitment appellate committee had also recommended the same. And the recommendation of the fitment committee is binding in the state government. On the basis of that, the finance department has filed this affidavit.
You see, once the advertisement is done, and if you are worried about what will happen in future, what will happen to other persons, you can certainly say that even if there was some error in the advertisement or whatever, if it was contrary to whatever their decision, but so far as these persons are concerned, you can't change it. It may not be treated as a pay scale for other employees for
Yes.
which appropriate advertisement is being made as per the committee recommendation or whatever. But that will not entitle you to, take away the pay scale which they are otherwise entitled. And how much is the difference? How much is the difference? Right?
400 rupees in grade pay.
Per month. No. So how much is the financial involvement?
Certain amount will be there because
आप हमको बताइए, because that is also equally important. For little amount you are fighting like this is not fair.
that
You should
that can-
have some assessment
yes.
that how many persons are there and what is the total financial implication per head and total, both.
That has not.
Right? You, being a welfare state, you can't behave in this manner. Not acceptable. Even if you have committed some wrong. But they have acted pursuant to your wrong, absolute bona fide. You have paid them salary. And then you want to recover and revise the salary to their detriment. कितना पैसा तो आप ऐसे ही बर्बाद करते रहते हो. Petitioner has to say something. You want to file anything?
No.
That should be sufficient. This is it.
It's-
इसके अलावा तो कुछ नहीं.
That's sufficient.
Nothing more.
Nothing.
कितने लोग हैं total? How many persons have been recruited?
In my case, we are from.
They must be having the idea. How many persons have been recruited pursuant to this advertisement? How many persons?
In one case, the association has. So
That is in the advertisement lordship से page 36 of.
How many vacancies?
Yes, if the vacancies was total नहीं total 1830 of all categories. 1836 of all categories. That is in the advertisement itself.
You see, I'll pass an order tomorrow, right? You seek instructions as to how much is the financial implication in total and also per head.
if you also can grant some more time so that
नहीं
some
देखिए
calculation.
ये इससे it makes no difference to the court, right? It makes no difference to the court, whatever be the financial implication. But still, I wanted to know if you are able to give that data, it's okay. Otherwise, we will decide it on whatever the material is.
I will
ठीक है.
ask the department.
You try to figure out. Let us figure out. Because that is also a very serious bearing. कितना आप litigation में कितना इधर उधर पैसा बर्बाद करते रहते, गाड़ी खरीदते रहते बिना काम।
एक केस का एक पिटिशनर का भी हो जाएगा तो इनटू
हाँ, बस एक ही petitioner का आप पता
पता
ठीक है? How much is the implication? इसी से पता लग जाएगा. Total we have that we
Yes.
can multiply, right? ठीक है. The matter has been heard. Post this case for further hearing tomorrow to be taken up at 2:15. ठीक, तो सब पता कर लीजिए.
हाँ
ये सारा रिकॉर्ड में आ गया, इनका एफिडेविट आ गया ना. भाई जो भी है आपस में एक्सचेंज कर लीजिए आप लोग. ये इंटरवीनर, हु इज इंटरवीनर?
yes Lordship. Because on last occasion the example of Gonda district was being cited, and therefore a candidate from Bugla has brought his pay scales, its joining letter, etc.
It's the same thing? Same thing or different?
Same thing, Lordship.
Same as-
But
We will
they were stating that Gumla is getting 200 grade
So
pays.
that is not correct.
That is not
On the,
correct.
on the last occasion he came later on,
Yes.
and he said that that submission is not correct.
Yes, Lordship.
Then I told him that on the next day we'll take care of that.
Yes.
So he came, I remember, he came
Yes.
on the last day.
Therefore an IA has
But
been
intervention is not actually not required.
Then, my lord, in WPS 2647 of 23, Finance Department, in reply to the letter of Deputy Commissioner Munda, has stated that entry rupees 9,910 दे होगा. And as per the Finance Committee recommendation also, my lord, which they have filed, the corresponding grade pay is 24.
In my case, my lord,
So in one of the cases, the finance department had responded in your favor.
yes, yes. In my case also, my lord.
You
In
do,
my case also.
you see, you do one thing, you prepare a note, right? You prepare a note, and then that will be of great help, because at the time of advertisement also maybe that they had consulted the finance department.
That is
So
there.
that will,
yes that is
That is there.
Gumla
so this is
Yes.
very important.
My lord, I got that.
This is extremely important that at one point of time the required consultancy
Was
etc. was done,
Done.
and they are revisiting their idea about the pay scale. So that will help me to pass an appropriate
Yes,
order.
Lordship. I find
In
that
case of Gadwa, my
You
lord,
please
it is there.
join, you all of you join yourself and then refer to that particular document wherever
Right.
it is. We'll pass the order tomorrow.
Yes. I find all documents.
If you are,
And
if
what
you
my
are
friend
able to
was
prepare
stating,
it,
my lord, what
if
my
you are
friend was
able to
stating
prepare it,
660.
just a minute.
That
If you are
660 is
able to
also there.
prepare, if you are able to prepare your required list of dates or whatever, by late evening also you send it to the court master. I will get it by late evening also. I will see and come.
We'll try our best.
Please do that. Otherwise नहीं हो पाएगा कल,
My lord.
है ना? तो गोराई जी को जरा बुलाइएगा. ये पूरा बैच जो है इनको दे दीजिए, ठीक है? और मुझे केस का पूरा प्रेयर वगैरह सब चेक करेंगे, सेम है क्या है ना? जितना आइए वाइए है सब चेक करेंगे.
Auto turn mention case from daily list item 23, WPS 3700 of 2023.
Paragraph 8 to 9 of contract of 6-7 we can be receiving.
WPS number 3700 of 2023. Counsel for the parties are present. Counsel for the respondents has submitted that all the grievance of the petitioner has been redressed, and it has been stated so in the counter affidavit. Counsel for the petitioner does not dispute the statements made in the counter affidavit, and accordingly he submits that he does not want to proceed further in the present petition. In view of the aforesaid facts and circumstances, this petition is disposed of as such. Prayer quote कर. कौन सा पैराग्राफ बताए थे?
8 onward है.
8 onwards. 8 to
8.
9,
8 and 9. That
8
is
and 9.
8 and 9.
8 and 9. ठीक है? 8 and 9 को quote कर देंगे. Of counter affidavit dated ये last वाला होगा. 18/3/24.
in
1/3/24.
David 1/3/24
18 है, the respondents state that this court in WPS number such and such by a judgment held that the petitioner would be entitled to 75% of the back wages. यही है ना statement?
That is humbly submitting the answering respondent revise the pension of the petitioner from the month of February and treating the petitioner as supernumerary and such and such. 1/3/2024 कहना चाहिए.
अच्छा अच्छा. 8 and 9.
हाँ 1 है.
Okay. ये वाला है paragraph. 8 and 9 of affidavit dated 1/3/2024 of counter affidavit filed on behalf of respondent number 6 and 7.
From supplementary list, item 14, WPS 6916 of 2023 along with item 15.
Petitioner?
Leadership has already passed similar orders in similar matters
You are for the petitioner?
for this one. Same category leadership in this also.
There is no rejection.
No relation. Their representations is a Annexure 6 series. Starts at page 52.
No, they are seeking quashing of the order dated 15/10/2023.
They had applied online leadership. Their online application was rejected, and that they have asked for.
Yes, are you there?
Yes.
Let's take one by one. This is 6916.
Yes.
He is agreeable to the order in the nature of WPS number 5821 of 23. You were there?
Yes.
Okay. There is a prayer to
Quash, my lord.
quash also. So I
Yes,
just want to know.
Yes, my lord, because they
In
have.
the earlier writ petition, there was no
there
prayer
was
to quash.
it was pending.
Yes.
Before. Now in this petition, they have rejected my online application on the very ground that there is no such provision for mutual transfer.
So that has to be set aside now.
That has to be set aside.
What is your response to that?
We have stated that there is no provision as such in
So
my order.
now there are orders which have been passed by this court. You say
Your Worship, just one more thing. In their application, which they had submitted online, there was no document which was uploaded as to who in the family was to be taken care of. There was no medical document.
They have
That's
to
why it
take a
was rejected.
decision.
Your Lordship may kindly see
no.
their online
It is
application
one thing
for
to say that there is no such provision. It is another thing to say that it is applicable under certain circumstances. So is it? It is applicable under certain circumstances.
Your Lordship, according to my counter, we have stated that there is no provision.
Then we have to adjudicate this. How can a order like this can be passed? You tell us how there is no provision.
Your Lordship, because para number 10 and 11 of my counter affidavit may be seen for.
You have to show it from the provision itself.
Resolution is at Annexure 3 series. Relevant part is at page 32.
32.
Page 32, ma'am. Para page 32.
Yes.
C6.
Let him place. He says that there is no provision.
Yes.
Yes, please read it
Yes.
and demonstrate that there is no provision for inter-district
Mutual transfer.
mutual transfer.
स्थानांतरण हेतु सामान्य सिद्धांत इस नियमावली के प्रावधान के तहत किसी भी शिक्षक का किसी विशेष क्षेत्र के विद्यालयों में स्थानांतरण का स्थापन का अधिकार नहीं माना जाएगा. There is no vested right to it. छात्र हित तथा निर्धारित मानकों को ध्यान में रखकर ही स्थानांतरण पद स्थापन किए जाएंगे. The student teacher ratio. स्थायी भाषाई शिक्षक का पद स्थापन छात्र संख्या शिक्षक की संख्या को ध्यान में रखते हुए आवश्यकता अनुरूप किया जाएगा। विषयवार शिक्षक के मामले में भी छात्र संख्या तथा शिक्षक के निर्धारित कार्यभार के अनुरूप किया जाना है। कोई भी शिक्षक अंडर यूटिलाइज ना रहे ताकि आवश्यक वित्तीय भार राज्य सरकार पर ना हो। सभी संवर्ग के असाध्य रोग दिव्यांग महिला शिक्षिका एवं अन्य गंभीर परिस्थितियों वाले मामलों में उनके आरक्षण कोटि वेतनमान विषय जो उनके मामले में लागू हैं के अनुसार अपने संवर्ग में पारस्परिक स्थानांतरण के संबंध में संबंधित निदेशक द्वारा विचार पर निर्णय लिया जा सकेगा, परंतु इसका अधिकारपूर्वक दावा नहीं किया जा सकता।
This is, you see, there are certain circumstances where mutual transfer is permissible.
But it cannot be done as a matter of right.
It can never be, transfer can never be a matter of right. So there is a provision for mutual transfer.
Yes, there is.
Then under such circumstances, how do you justify your counter affidavit that there is no such provision? There are certain circumstances. That's it.
Those circumstances has
If
not,
they fulfill, it's okay. If they don't fulfill, that is their problem.
they have not fulfilled it.
May
That's
not
what we
have.
can say.
Where is the order of rejection?
Yes. That is kindly see my lord, page 51. 51.
Yes.
Last.
Huh.
Application rejected by officer on 15th October 2023 remarks, mutual transfer application is not valid in departmental instructions.
So it has been rejected as if it was not maintainable. It is maintainable, but they may be entitled, may not be
The
entitled.
leadership can pass a direction, we can reconsider his application which has already been given at an interest.
WPS number 6916 of 2023. Counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has relied upon an order passed by this court in WPS number 5821 of 2023 and has submitted that the matter relating to inter-district mutual transfer in the matter of assistant teachers.
Yes.
Only assistant teachers?
Assistant.
In the matter of teachers appointed by the state of Jharkhand as per their policy decision contained in Annexure 3 series, was subject matter of consideration before this court in WPS number 5821 of 2023, and by referring to clause 6 of the aforesaid provision, it was observed that there is a provision for mutual transfer as per clause 6 of the circular, but at the same time the petitioners cannot claim it as a matter of right. The learned counsel submits that as per the impugned order, the prayer for mutual transfer has been rejected Where is it? Page number?
Page 51.
Has been
Annexure 5.
just has been rejected by stating that mutual inverted comma mutual transfer application is not valid in departmental instructions. His application is rejected. Inverted comma the last one, page 51. The learned counsel has submitted that the said order has been sought to be justified by filing the counter affidavit stating that there is no provision for mutual transfer. During the course of hearing, the learned counsel for the respondents has placed the aforesaid clause 6 of the circular and has submitted that, and during the course of hearing it also transpired that as per clause 6 within bracket within bracket Roman 4, there is a provision for mutual transfer which is required, whose application is required to be considered by the director of primary education.
Respondent number?
By the director of primary education, but he submits that only under very limited circumstances the same is permissible, which has been mentioned, and the circumstances has been mentioned in clause 6 itself. At this, counsel for the petitioner has submitted that the prayer for mutual transfer has been rejected by stating to be not maintainable, and if the petitioner falls within the permissible clause of mutual transfer, then the respondent number 2 may pass appropriate order, and for that purpose the impugned order be set aside. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that as per clause 6 of the aforesaid circular contained in Annexure 3 series, there is a provision of mutual transfer, though under limited circumstances. However, the impugned order has been passed under the impression that there is no such provision. Accordingly, the impugned order cannot be sustained in the eyes of law, which is hereby set aside. The matter is remitted to the respondent number 2 to pass a fresh order regarding the mutual transfer upon an application to be filed by the petitioners. There are 2 petitioners.
Yes.
Within a period of 1 week from the date of such representation, along with a copy of this order, a copy of the writ record, and also a copy of order passing WPS number 5821 of 2023. The decision so taken pursuant to this order be communicated to the petitioners through speech. That's all.
Next case number, perhaps all cases have same on the
Same. There is an order of rejection in all the cases.
No, not in all cases.
This is
In WPS number 6925.
6925.
Yes.
Yes. You are seeking a mandamus.
Seeking a mandamus.
So it will be same as 5821,
5.
right? Annexure 3 series.
Yes, Annexure.
692523 is same as 5821 of 23, right?
And WPS number 6914.
6914.
Here we are seeking for caution.
You are seeking caution, and what is the reason for refusal?
Kindly see.
And what is the counter?
Yes. Kindly see the reason is Annexure 5 series, page 56 and page 57. Remarks, application rejected by officer on 8th October 2023. Remarks, mutual transfer is not acceptable as per policy. And in 57 also, application sent back for modification by order.
सर मैं रीजन ऑर्डर का ऑर्डर कर क्योंकि ये ना एक लाइन का ठीक नहीं पेज नंबर
Page number 56.
all right and as per the counter affidavit it is there is no such provision
In the counter.
Yes.
the counter
no such
affidavit इसमें how many petitioners are there
Two petitioners.
two petitioners so petitioner number okay in all the cases there are two
Two
petitioners
petitioners. They are praying for mutual transfer. Page 56 and page 57. Both of them have filed application. Both application have been rejected on the.
in page 56 it is at the bottom last one
Mutual transfer is not acceptable as
yes
per.
that's right and in page 57
Page 57. 8th October. Application rejected. Bottom page ऊपर एक ऊपर.
हाँ.
Application rejected by officer on 8th October. Remarks. Medical certificate does not belong to candidate.
इसमें तो they have cited some reason also
ये इनका ये और एक एप्लीकेशन रिजेक्ट हो गया कि मेडिकल म्यूचुअल ट्रांसफर इज नॉट एक्सेप्टेबल.
इसमें तो there is a reason
अब इसमें ये भी है कि ये रिजेक्ट
they were
रिजेक्टेड बाय
mutual
डीएससी. ये है रिजेक्टेड बाय डीएससी. इट हैज टू बी रिजेक्टेड बाय द रेस्पोंडेंट नंबर 2 बिकॉज़ ही इज द ओनली अथॉरिटी हु कैन कंसीडर. नाउ इसके जस्ट ऊपर देखा जाएगा एप्लीकेशन सेंड टू डीएससी.
कौन सा मेडिकल सर्टिफिकेट आप लगा रहे हैं it is not the same thing it is not the same thing it is the you see you were claiming mutual transfer between the two petitioners
बिटवीन टू.
right for one the this medical certificate does not belong to the candidate
लेकिन इनको रिजेक्ट भी किया है डीएससी ने. डीएससी इज नॉट एन अथॉरिटी टू कंसीडर माय म्यूचुअल ट्रांसफर एप्लीकेशन. द प्रॉपर अथॉरिटी हु कैन रिजेक्ट माय एप्लीकेशन इज रेस्पोंडेंट नंबर 2.
आपका मेडिकल सर्टिफिकेट आपका होगा ही नहीं तो इट विल नॉट बी प्रोसेस्ड एट द थ्रेशोल्ड isn't it
Medical certificate does not belong to candidate. The medical certificate I have stated, medical certificate belongs to my family members. Because on the ground ki I have to look after my family members, I am seeking for my transfer. And we see the medical certificate. The
actually WPS number 6914 of 23 the learned counsel for the parties are present this petition has been filed for the following relief the learned counsel for the petitioner has submitted that petition number 1 and 2 had applied for mutual transfer and so far as the application of the petition number 1 is concerned the same was rejected by stating that mutual transfer is not acceptable as per policy and so far as petition number 2 is concerned it was rejected with a remark that medical certificate does not belong to the candidate. The learned counsel submits that the petitioner had filed the medical certificate of one of his
uncle and aunt who are blind.
Of his uncle and aunt
Who are blind.
who are close family members.
Uncle and own uncle and aunt.
Own uncle and aunt who are completely blind. The learned counsel has submitted that so far as the application of petition number 2 is concerned, the same was not placed before the respondent number 2 and was rejected at the threshold. He submits that as per the counter affidavit, there is no such provision for mutual transfer. He has relied upon order passed by this court in WPS number 5821 of 2023. The learned counsel for the respondents has placed the clause 6 of the notification contained at annexure 3 of the state petition and has submitted that mutual transfer though is permissible, but is permissible under very limited circumstances. The petitioner cannot have transfer as a matter of right. However, from the perusal of the rejection of mutual transfer of petition number 1, it appears that the same has been rejected under the impression that there is no such provision in the policy, and the same is sought to be supported by the counter affidavit filed by the respondents. Is that correct? You have taken a stand to that effect?
6914 is not present. हमने बोला अभी की बात है हम लोग 6925 में है ही 6916
I'm only serial number 14.
6914 में कौन है?
मिस्टर रवि करके टाइप है आई इन्फॉर्म
ऐसे नहीं होता है ना. I am recording his submissions.
my lord he should have been here I'm just calling
ये जो प्रॉक्सी आप लोग का कोर्ट कॉलेज में चलता था ना, कोर्ट में नहीं चलने देंगे.
नहीं मेरे पास फाइल भी ना हम तो अपना केस में खड़ा थे मैडम
हाँ, तो when I am dictating the order in the third case, you are nodding your head, and when I ask you, you say that the counsel is not here. You should have said at the threshold that he is not here. Yes. Yes. What is your case?
For the promotion,
Promotion.
6914
इसमें करिए 6914 of 23. Counsel for the petitioner is present. Nobody appears on behalf of the respondents. Post tomorrow. उनको बिना सुने ऑर्डर नहीं कर सकते because there is a reason given for rejection.
6925 is same no order has been passed
That is correct.
6925 that is my case
6925.
yeah here's come 6914
No order has been passed in 6925. No, they have cited reasons that it does not fall in the category.
Yes, in the counter we have cited reason that they do not come in the scheme.
So how do you say that no order has been passed?
No, we are saying that each case cannot be considered because there is no order as such, my lord.
No order has been passed.
No.
You have simply stated in your contract.
Yes, sir. We have simply stated that their case do not fall in the scheme, therefore it cannot be considered. This is what we have said. There is no order.
इसका लिखिए WPS number 6925 of 23. This petition has been filed for the following relief. The counsel for the petitioners has submitted that the petitioners have applied for mutual transfer, but no order has been passed. though in the counter affidavit it has been mentioned that the case of the petitioners do not fall within the provision for mutual transfer.
Yes.
The learned counsel submits that since no order as such has been passed, the matter be remitted to respondent number 2 to pass appropriate order in terms of the scheme. Learned counsel for the respondents has submitted that there are very limited grounds available for mutual transfer. However, the matter can be considered by respondent number 2 who shall pass reasoned order.
Yes.
ठीक है, बाकी सब same. Petitioner has relied upon WPS number 5821 of 23. This is disposed of 6914. ये कल.
Yes.
Yes. पास ओवर. ठीक है, कल सुनते हैं. दो चीज़ें मेडिकल डॉक्यूमेंट्स लगाए हैं इन्होंने, शायद किसी अंकल का लगाया है और शायद DAC ने ही रिजेक्ट कर दिया. इट हैज़ नॉट बीन प्लेस्ड बिफोर द कंसर्न्ड अथॉरिटी. दैट शुड नॉट हैपन. इट शुड गो बिफोर द कंसर्न्ड अथॉरिटी. ठीक है, कल सुनते हैं इसको. एक को कल कर दीजिए. देखिए 2-3 ऑर्डर्स हैं. ये एक कॉपी जो है ना, ये तीनों की, ये 2-3 की उनको दे दीजिए और इसमें भी एक लगा दीजिए. ये डिस्पोजल ये एक ना पूरा बैच है. उसमें एडवर्टीजमेंट हुआ था फॉर अ पर्टिकुलर पे स्केल एंड देन द पे स्केल हैज़ बीन रिड्यूस्ड. वो सारा बैच का प्रेयर मैच कर लीजिए. उसका पार्टी नेम प्रेयर थोड़ा सा मैच करके देख लीजिए. इफ इट इज सेम इट्स ओके. थोड़ा इतना काम करिए, कल के लिए रखें.
Item 16, WPS 7302 of 2023.
This petitioner.
ये application has been filed for amendment.
Amendment of
Now they are challenging the one written by which was they have been directed to produce the OBC certificate from the state.
From Jharkhand.
Although from the petition, interrogated petition, it is not clear which prayer they are making in fact, the content, what exactly they intend to insert in the main petition. It appears to be a supplementary after with a prayer.
they are seeking to challenge Annexure 9. Where is Annexure 9?
That is a page, annexure, page 1240. Annexure 9, page 39.
The selection process is over.
Lord, in fact, my Lord, we have received one instruction to the FS, my Lord, they have asked for some more time because inter-department, there are several departments in which, my Lord, they have to consult with regard to the reply. So therefore, my Lord, I have, yesterday evening, my Lord, I have asked them to supply so far at the query which I have made with them.
Let us just have a look. What was their objection regarding their OBC certificate?
My Lord, the case is, my Lord, that so far as the application which has been submitted by them, my Lord, they have given the OBC certificate from the UP, my Lord. They have given the address of Jharkhand. My Lord, therefore, my Lord, so far as that part is concerned,
They originally belonged to which place?
My Lord, so far as that part is concerned, my Lord, they are shown to be a Jharkhand.
She belonged to UP originally. Presently, she is residing here. Her education is here. Her other parents are here.
She has submitted the OBC certificate from UP.
OBC certificate I'll be voting from that state, my lord.
Your family members never had OBC certificate. Is it
Family
for the
members?
first time you are getting the OBC
My
certificate?
lord. First time because it was needed.
Where have you stated that you originally belong to UP?
Application is OBC certificate itself is written, my lord. OBC certificate is page number 32, my lord. Annexer, page 32. Annexer 6, page 32.
See,
Resident
OBC,
of
any
Chandwa.
caste certificate has to be issued from the place of origin. It cannot be issued from any
so
other
far as
state.
that part is concerned, my lord, I have instructed them to bring all the policies, my lord, because the letter which I have received, my lord, on mail, my lord, that does not speak. They have simply said they intend some more time for filing reply, my lord.
We had passed a judgment in Mittupassi, in which all the circulars of the government, central government, has been mentioned, has been considered.
Yes,
There the candidate belonged to state of Punjab.
State of Punjab. That may be, my lord, I am not saying so far
No,
as
you
that
will
part,
have the
moment-
reference of all the circulars of the government.
Yes, my lord, I have instructed them, yes, so far as the policy.
So let us, at least this amendment should be allowed. Let him file an amended petition. You file a reply to the amended petition.
Yes, my lord, there is no difficulty, but the format, what is to be included, my lord, that has not been mentioned in the petition. It's like a
He wants to
supplement.
challenge Annexure 9.
Yes, my lord, that I can understand, my lord. But the amended petition, let them file, my lord. If that
You
is
file
the-
your amended
The proper petition should have been filed, my lord, that.
इसमें तो letter number is specific it is written, my lord. That has to be questioned.
That is not the
ऐसा
format
है
for
ना
the amendment.
कि आपको पता नहीं है कि अमेंडमेंट कैसे बनता है. यहाँ पे काउंसिल लोग ढंग से अमेंडमेंट बनाते भी नहीं. You have to specifically state कि इस पैराग्राफ के बाद ये पैराग्राफ इंसर्ट करना है, इस
Prayer
प्रेयर
में
के
आएगा,
बाद ये
contents
प्रेयर
में
ऐड
आएगा,
करना है. This is not an amendment petition at all. We are not so.
What is to be incorporated in the main
It's
petition?
not
That is not
mentioned.
it.
उतना बार हम कर दे रहे हैं, इतना हमको
Your
टेक्निकलिटी
Lordship
में
may
नहीं
permit, my
जाते.
lord, that liberty, my lord, can be given.
I have-
Prayer with regard to Annexure 9, washing of Annexure 9 is permitted to be added. That should be sufficient. Learned Counsel for the parties are present. IA number 909 of 2024. The Learned Counsel for the petitioner submits that due to inadvertence, Annexure 9 to the writ petition has not been challenged, whereby the petitioner has been asked to produce the OBC certificate issued from the state of Jharkhand. He submits that the petitioner belongs to state of UP and therefore OBC certificate or caste certificate, if any, is required to be issued by the person, by the place of origin of the person. Counsel for the respondents has submitted that no counter affidavit has been filed in the present case, but he has no serious objection to the prayer for amendment. The petitioner be directed to file an amended writ petition. After hearing the counsel for the parties and considering the nature of relief sought for it through the interlocutory application, this court finds that the prayer is the prayer will not change the nature of the writ petition. Accordingly, IA number such and such is allowed. The petitioner is directed to file amended writ petition within a week from today, incorporating the prayer for challenge to Annexure 9. Let the counter affidavit be filed by within a period of 4 weeks now.
Thereafter.
Let the counter affidavit be filed within a period of 4 weeks
After service of the
upon service of the amended
petition.
petition. Pose this case on 10th July
Yes, sir.
in the supplementary cause list. ये सबको पेंडिंग रखना ठीक है.
मैंने जून में कभी ले लिया था, अच्छा था.
जून में थोड़ा हम लोग छुट्टी पर हैं. थोड़ा वेट करिए. Have some patience. कोर्ट बंद है ना, मई जून काफी दिन बंद.
From daily list for admission item 8, WPL 2144 of 2015. Along with item 3 from supplementary list.
There is a petitioner of item 3 in the supplementary list. You are there? आप हैं? Item 3 में आप appear हो रहे थे? Both these cases are arising out of the same proceedings. इनको जरा दीजिए, इनको दिखाइए. आप अपना रिट उनको दिखाइए. You have challenged the award passed in reference number 323 of 20. Mr. Mehta?
Yes. Yes, 323 of 2000.
Oh, sorry.
Yes.
323 of 2000. This is also arising out of 323 of 2000. So these two matters you have not appeared in the other one?
The other one I have to notice. I have not been interested in this case.
This is Coal India Limited, Eastern Coalfields Limited.
I know.
You are appearing for Eastern Coalfields.
Eastern Coalfields in the first 2144.
You see, it is arising out of the same award,
Yes,
so you
yes.
seek instructions. You want to file wakalatnama separately?
I will have to file a wakalatnama because unless they authorize me.
That's right.
Uh,
There is a
and one
private
more thing.
respondent also. There are private respondents also
Private respondents.
in their case.
Oh, yes, you can. Yes,
Are you appearing in this case, Mr. Counsel? They have entered appearance. In your case, the respondent has entered appearance.
I'm not sure. Just wait. I'm not asking you. There are two advocates who are appearing in my case. One is Manoj Kumar, the other is Shiv.
In your case, the notice is validly served.
And the lawyers are also appearing in the cause list, I can see.
Today they are absent. And so far as the other case is concerned, the petitioner is Bhartiya Coal Dump. So,
Yes. In
yes.
this case, I'll be appearing for respond number at best 4 and 4,
5.
5 also. 6 I do not appear. I will not appear. Notice will have to go. I do not know why they have
6 and 7, the notice has been served. 8 also notice has been served.
6, 7 and 8 notices served.
Yes.
Yes, then it's all right.
6 and 7 notice has been served.
Right, no.
Notice has not been issued upon respondent number 8. Why is respondent number 8 made a party?
Not at all necessary.
Partner in BAL project.
BLA is the contractor. It's a partner.
6 and 7 has appeared, so 8 is one and the same.
Yes.
So you will appear on behalf of respondent number 4 and 5.
4 and 5. I can appear. And
लिखिए.
your lordship may grant me some time.
I will give you some time. WPL number 2144 of 2015 with WPL number 4272 of 2021. Mr. A.K. Mehta, Learned Counsel submits that both these cases arise out of the same award. He submits that he shall seek instructions and file wakalatnama on behalf of respondent number 4 and 5 in WPL number 4272 of 2021. Counsel for the petitioner in WPL number 4272 of 2021 is directed to serve 2 copies of the entire records of this case upon Mr. A.K. Mehta within a period of 1 week.
1 week.
पूरा record दे दीजिए हमको. He will seek instructions and file a वकालत.
One more thing. The lordship may call for the records.
Records are there.
There.
It has already come.
So I'll be arguing on the basis of recent order passed by your lordship. Because it's a critique award.
Okay.
So that order I will produce on the next date. Your lordship has
Same officer.
same officer. Same officer.
The
is on
learned
this-
counsel for the petitioner, Mr. A.K. Mehta, in WPL number 2144 of 2015 has submitted that the impugned award in the present case is a cryptic order, and he has relied upon order passed by this court in WPL number
6053 of 2000.
6053 of 2018.
is dated
8 dated 8/4/2024. The learned counsel has also submitted that only one opportunity was granted to the petitioner to adduce evidence. यही है ना आपका केस?
मेरा केस में तो
एक
हम लोगों ने एविडेंस लीड किया है उसमें
नहीं,
कोई-
आपने नहीं ली.
जी।
आपने नहीं ली.
अच्छा विटनेस हमने एग्जामिन नहीं किया है सही बात
Only one date was given to you.
हाँ यस उसके बाद क्या है ना जो एविडेंस भी आया है उसको भी डिस्कस
हाँ, that's right. But that is
Ah,
also
yes.
one of your
यस
grievances.
आई डिड नॉट प्रोड्यूस इवन अ सिंगल विटनेस
अब बताइए कब करेंगे? एक हफ्ता तो आप इनको आज दे दीजिए कॉपी.
अच्छा ठीक है तो
उसके बाद 2-3 हफ्ता हमें दे दीजिए 2 हफ्ता कम से
वकालतनामा फाइल करने के लिए.
वकालतनामा फाइल
रिकॉर्ड आ गया है. इसलिए
आगे
कोई
से
बात
आई
नहीं.
डिड नॉट वरी खाली वकालतनामा हमें फाइल करना है
ठीक.
दैट इज ऑल
पोज दिस केस ऑन. ये ऑर्डर पढ़ लीजिएगा क्योंकि एक ऑर्डर किया हुआ है अंडर सिमिलर काइंड ऑफ अवार्ड और तैयार होके आइएगा. दिस विल नॉट टेक मच टाइम. ओके. कौन है काउंसिल आपके जो बहस करेंगे इसमें? एक हफ्ता बाहर है वो.
हाँ
Pose this case on eighth of May 2024 under the heading of no 8th May तो नहीं हो पाएगा. On 3rd July 24 under the heading of final disposal. ठीक है?
कुछ केसेस में कॉपी सर्व करने में बहुत देर लेते हैं
नहीं,
तो
आप
हम
देर
लोग
मत
को
करिएगा.
अभी एक 3 केसेस आ रहे हैं आपके पास रिव्यू का 1.5 महीना लिए कॉपी सर्व करने में हम लोग को भी थोड़ा सा टाइम लगता है फिर हम नेक्स्ट डेट फ्राइडे को लगेगा हमको टाइम देना पड़ेगा
अभी ऑर्डर ऑलरेडी हो चुका है. हाँ, ऑर्डर ऑलरेडी हो चुका है.
जो सर्विस ऑफ
विद का
हाँ विद का हो चुका है
Item 9, WPL 2771 of 2017.
list of dates.
Yes.
That's the award which is due is at page 27.
What is the ground?
But I have got two grounds. The initial reference was made with respect to two issues. Whether the deduction of the penal rate for the period December 1986 to October 1990 was justified or not. And the another aspect, whether the wrong fixation of the scale of the said workman was made from 21/6/1979 till the date of the arrest. Now, there is no finding with respect of the either issues. The first prayer was allowed on the ground that in 1986, the period which is not covered under this reference, once you have deducted penal rent, lost, appeal also lost, therefore nothing to be considered. This time also deduction of penal rent is unjustified, relief granted. So far as second aspect of the matter is concerned, the grant of the wrong scale. Again, there is no finding as to how. The only one aspect which was considered by the learned industrial tribunal is that when he was granted promotion, his first wrong salary is less what he was drawing before the date of promotion. Therefore, we have not granted appropriate. Whereas our case is
उसमें एक order था ना WPA में
whereas the workman itself has not demonstrated anything that how the fixation is wrong. Now, its finding for both the issues is my important. The finding with regard to the penal rent is at paragraph 20. This is the only ground by which it is decided that charge of penal rent is wrong. The issue of penal rent has already been decided and confirmed by the appellate authority marked as Exhibit W2. It is with respect of some other period. It is not res integra now in this reference case. That apart, the management implemented the said order and refunded the deduction of the earlier period of different spend at the rate of rupees 477 per month towards penal rent in respect of the above quarter. I accept that. This tribunal, in absence of any fresh evidence and document, cannot hold otherwise. That apart, management company has not denied deduction of penal rent for the aforesaid period. Now, this finding, okay, in 1986 January, I have wrongly deducted. He has filed PW case, then the appeal was also dismissed, and we have returned. But in this reference, the period is December 1986 to October 1990. How can in an earlier proceeding, which is with respect of some other period, since I have lost, therefore there is no ground to this finding is being challenged on this ground. And then, my lord, so far as grant of the wrong pay scale is concerned, my lords may come to paragraph 23. This is the only relevant paragraph by which it was held that we have wrongly granted. The second issue, paragraph 23, the second issue of wrong fixation is that the office order dated 17/18 to 1992, marked as W5, which is also marked as M4 as management document, on simple look, as on 1/9/1978, pay of Sri Agarwal on promotion was fixed at rupees 881 revised. But surprisingly, on 21/6/1979, it was reduced to 850 on promotion in E1 grade, which ought to have been 950. Now, where is the evidence that it ought to have been 950? On what? What basis it was decided that it ought to have been 950? There is no material available under it. Now, this is fourth round of litigation by the respondent hearing.
Mr. Das, is it not a triptych award altogether?
So it will not be a triptych. Why I am telling you, Lordships? First, penal rent. Lordships, if penal rent can be deducted only if I am in an unauthorized occupation of a quarter, after retirement or otherwise, or if I am retaining 2 quarters, anything, there has to be some justification why a penal rent. previously they were wrongly deducting. So I challenged it. They could not justify. Still they went up to appellate stage. They could
No,
not
we do
justify.
not know what was the ground for deduction.
Also, they have let them say they are there before this honorable
No,
court.
no, we are not in a writ jurisdiction.
No, no.
You see, we
Admitted
will
facts.
scrutinize the award
Yes.
on the basis of the discussions and
Yes,
findings
the
made in the
discussion
award.
is your lordship.
So what is the basis of this discussion in para number 20? You just tell us, can
Yes.
we understand anything out of it?
Lordships, para
We
number
will
20.
not, we will not scrutinize the documents and then come to a finding, isn't it? That is not the
No,
scope
no.
of
Lordship will
this.
not scrutinize. The tribunal says, your lordships, that previously also they had wrongly deducted for the just continuous period. It is for the continuous period. Suppose till September 86, their action has been held to be illegal. They said very well till September I will, but I will continue recovering deducting
But
penal
it
rent.
is not appearing from the award that this is the situation.
I'm just.
There
I'm just
could be,
reading
you
out,
know,
yes.
deduction of penal rent on various circumstances. Delay in payment of rent could be one reason, right? Part payment could be another reason. We do not know as to why and under what circumstances, under the previous orders, the penal rent was deducted.
Lordship, can you
Is
see
there any
para 5,
finding?
para 5, your lordship, their pleadings, let them show, lordship, one line, what justification they have given. Their
No, no.
entire written
You see,
statement.
we
has
will
been-
not, we are not in a writ jurisdiction, I'm reminding
No,
you.
your lordship is in a root.
I want to know from the award itself.
Yes, from the award
No,
only. Can
we
you
are
see
not
para
in
5?
a, you know, regular 226 application. This is, we have to find the perversity in the order
Yes,
and
yes.
set it aside.
Lordship, I have a workman
I'm not able to comprehend what the finding in para 23.
Yes, I'm just coming to it, your lordship.
You read the award and let us see if we are able, if it is comprehensible, there is no problem.
Yes,
about it.
yes, lordship.
Read the award. The case.
Lordship, from para 3 I am married out, your lordship.
You read from para 2 only.
As
Read
well.
from.
The case is received from the Ministry of Labour such and such. The workman files his written statement on 21/9/2012, but management filed the written statement on 8/1/2013. Thereafter, the rejoinder and documents were filed by the parties. One witness from either side, each side has been examined on behalf. The documents of the management has been marked as M1 to M6, and documents of the workman has been marked as W1 to W6. The case of the workman is that workman concerned was appointed on 24/11/70 and a residential quarter number such and such was allotted to him. He occupied and resided therein along with his family members. But the management illegally started making deduction of penal rent from the wages of the workman at the rate of 477 per month with effect from June 1986 without the consent of the workman and without any reason. The workman protested against the illegal action of the management in the matter of unlawful deduction, but the management have not stopped making deduction of penal rent from the wages of the workman concerned thereafter. He filed a case under section 15(2) and 3 of the State Labour Court BSCT, which was awarded in favor of the workman and directed the management to refund the amount deducted from the wages of the workman. He also filed a case under 33A of ID Act before the State Labour Court Bokaro, raising allegations of change of service conditions by way of denial of promotion, supersession of juniors, etc., which were numbered as Miss Case number 10 of 1986, and the Labour Court Bokaro rendered an award in favor of the workman, granting promotion along with consequential benefit. The management filed a writ application bearing CWJC number 1485 of 91 before the Honorable Patna High Court Ranchi bench, and the order passed in favor of the workman and directed management to implement the award of the Labour Court. The management implemented the award of the Labour Court Bokaro. The promotions was also making payment of consequential benefits, but the management filed LPA against the order of writ court, which set aside the order of single judge. Thereafter, the workman filed special leave petition before the Supreme Court against the order of division bench of the Honorable High Court, which was disposed of by the Supreme Court by an order that the position of Sri C.P. Agarwal should not be disturbed as the management has already implemented the award of the Labour Court Bokaro. It is further submitted that workmen and that management made deduction of penal rent from the wages of the workmen alleging unauthorized occupation of the quarter for the period June 1986 to 1990 to an amount of Rs 2,385. The concerned workman filed a claim application before the presiding judge Labour Court Bokaro under the provisions of Payment of Wages Act, which was numbered as PW case number 22 of 86, and the London Labour Court passed an order dated
21/12/1988 deciding all the issues of the management in favor of the applicant, but the management did not make payment of the penal rent for the period in question, but preferred an appeal against the order of Labour Court Bokaro, which was numbered at Miss Appeal number such and such. But the appeal was dismissed by the Additional District Judge Bokaro on 13/4/2000. That it is submitted a workman that management continued deducting penal rent with effect from June 86 to 1990. Lordship, the period is the same, Lordship, can be marked. And the concerned workman's pay scale was also alleged wrongfully fixed by the management on 21/7/1979 by office order dated 18 to 1992, and it continued till the date of retirement, that is his VRS, which was challenged by the workman, but the dispute of the workman, hence industrial dispute arise. On the other hand, the management concerned workman holding the managerial post, as such he is not a workman. He was initially appointed as a construction supervisor with effect from 24/11/70. It is also submitted the management that Labour Court Bokaro passed an order on Miss Case number 10 of 86, wherein management directed to promote CP Agarwal to the post of construction supervisor grade 1 with effect from 6/6/1977, additional divisional engineer with effect from 21/6/1979, divisional engineer with effect from 17 to 1983, and zonal engineer with effect from 36/1987. Thereafter, the management challenged the award of the award before the Honorable High Court, numbered as CWJC number 1485 of 91. But during pendency of the writ petition, the management fully implemented the award of Labour Court Bokaro and gave all the benefits, including promotion and different wages. The Honorable Court quashed the award of the Labour Court. Thereafter, he filed civil appeal number 11547 and 11573 of 95 and the Honorable before the Honorable Supreme Court. The Apex Court, taking into consideration that promotion during the pendency of the writ petition, directed not to revert the workman to a lower post, hence received wages and other benefits more than he is entitled to. Still, he filed a case case being embodied as previous facts. MJ case number 5 of 89. The claim of the applicant was refund of the penal rent deducted from the management for the period December 1986 to April 1989, and which was dismissed by the writ court by Honorable High Court in WPL number such and such, which was also dismissed by the High Court on 6/11/2007. That we have produced this order on record. A 33C2 proceeding was filed. The court said it is not maintainable.
That the month is an error of record in view of page 18 of, because the application was filed for deduction of June 86 to October 1986.
It is further submitted that management that CP Agarwal, taking VRS as per management scheme, accepted all the benefits under VRS, and as such he has no claim, and he has raised a dispute after acceptance of all benefit. He illegally occupied the quarter, hence management deducted penal rent, which is legal and proper. His wage was never wrongly fixed on 21/6/1979 till the date of his VRS. Thus, his wages was fixed as per the rule of the company implemented by the order dated 17 to 1992 of Labour Court Bokaro. He received more wages than he is entitled to. There are 2 points to be decided in this court: that whether the deduction of penal rent from December 1986 to October 1990 and wrong fixation of wages from 21/9/1979 till the date of VRS is not proper or not. The management examined one witness, Ranodip Banerjee, DGM personnel of Bokaro Steel. He says in his cross-examination, which is quoted here under. The concerned workman joined BSL as a construction supervisor in the year 1977. The minimum qualification.
This is quoted.
Yes.
Then the High Court order is also quoted.
Yes.
Then how he jumps to the finding at para number 20?
Yes, I am coming to it, Your Lordships. The issue of penal rent has already been decided and confirmed by Exhibit W2. Lordship, it is confirmed up to appellate court. Kindly see the period, Lordship. Therefore, I asked Your Lordships that if the period of that is C.
Period is June 1986 to October 1986. And here the period is December 1986 to October 1990. My lords may come to
Earlier in appellate court, the period was
June 1986 to October 1986. It is at page 18 of the counter affidavit. They have filed the
That's
judgment.
right. And what is the period involved here?
Here is December 1986 to October 1990.
To October
1990. So that was for another period. This is for the another period.
He is talking about continuity of cause.
Yes, that was Lordship. Can you see when did I raise that dispute? In 1980s. Lordship, that application was filed on 1986. So I could have made a complaint only till the date of filing of the application. Despite this order, they continued deducting penal rate. Lordship, I was employed in the company. They allotted me a quarter. I was residing there. Then, in one line bold statement, Lordship, there has to be some basis to say that I was under unauthorized occupation. I took VRS, I left the quarter immediately. There is no allegation that I retained it for a single day more. Therefore, the court says in para 20, Your Lordship, that this has been adjudicated, that you have wrongly deducted. And there being no ground, they went in appeal.
And what about the pay scale?
Yes, kindly see the pay scale, Your Lordship, para 23. Second issue of wrong fixation of pay scale with effect from 18 to 1992, marked as W5, and which is marked as MW4 as the management. It is the common document, both are filed. On simple look, on 1/9/1978, Shri Agarwal was on promotion. Agarwal on promotion was fixed as 881, revised. But surprisingly, Lordships, on promotion I got 881, revised, and in 1979 they reduced it to 850. It ought to be 950 because my pay scale also he has mentioned 800 to 1400. If they give me an increment, it will not decrease, it will always increase.
No, from where does he get 950?
Lordships, we had explained it, Your Lordships.
Yes.
The pay scale is 800 to 1400. I was already in the scale of 881. The next increment, if added, it will come to 950. It is a clerical error on their part. And Lordship, this paltry amount, Lordship, I filed a 33C2 in all fairness, they should have come and said that I am giving you this money. They said, no, you raise an industrial dispute. 2300 and odd rupees, Lordship, for that this old man, and out of, for principles, Your Lordship, he is fighting. He had to leave the job, Lordship, after winning all the litigations, he applied for VRS.
When did he get VRS?
Lordship, 1992, 1993.
ना दिल लड़िएगा आप लोग. Yes, वो तो.
2300 कुछ रुपया के लिए, with interest hardly 1 lakh रुपया भी नहीं पहुंचेगा.
What is the amount of money involved? Who has retired in 1992? He must be around 90 years.
I don't know, 86, 87 years होगा.
Yes.
What is the exact amount, my lords? Now they are claiming somewhere around 2,28,524.
Refund.
Not only penal, wrong fixation, therefore 1986 every time pay fixation.
देखिए इसको remind नहीं कर.
That is my queries.
Not for such petty amounts, right? You are unnecessarily fighting. आप लोग कोई अपना mutual consent से कुछ amount figure करें.
If they give an offer, I'll convince my client.
Please look. क्या मतलब है?
Lordship,
You are still authority.
Minus 5 minutes.
Oh,
My
that is
senior
why-
is competent to give that much.
हाँ,
I am
very
asking
you
him.
call him. This is
5
too much.
minutes. He must be
थोड़ा सा
on.
चीज के लिए कितना
and
लगे?
Lordship,
5 minutes.
पे फिक्सेशन में तो बढ़ेगा ही, घट तो नहीं सकता.
There can be
छोड़िए,
instance.
we do not know. Hard to
That
fight.
happens, my lords. Basic is protected, not DA.
नहीं,
We can show the evidence that his pay
Call
scale.
your senior. We'll figure out if there is.
Yes, I am coming because
golden
that I
handshake.
cannot commit before my lords that yes, I will.
Call him please. ये 2 लाख के लिए हम आपको
It
इतना
is his
लड़ने का
word which
परमिशन
will be
देंगे.
followed by them. So, only 5 minutes I am just
हाँ,
calling.
please. ना लड़ते हैं. हाँ.
1993 से अभी तक का
अभी
दो
तक
लाख
का-
रुपये हो गए आदमी.
He has evicted the quarter, I suppose.
Yes, immediately, not a single day I have overstayed.
but its penal rate is very less. The actual claim is wrong fixation and he is claiming differential right from 79 till his date of
किसी
year.
का पे गलत फिक्स कर दीजिएगा. The shoe will
नहीं,
pinch
हुआ
very
नहीं।
hard.
नहीं हुआ।
बुलाइए कुछ
It's
golden
possible
handshake
for
करिए.
one case.
Because I told my client, छोड़िए ये सब, तो बोलते ना मेरे साथ गलत हुआ हम नहीं
तो कोई गोल्डन हैंडशेक के लिए तैयार करिए उनको।
नहीं उनको हम बोले थे, बोले आप बोले कि हमसे गलत किया, हमको आई वाज फोर्स्ड टू टेक बीआरएस, हम छोड़ेंगे नहीं, हमसे गलत
This is
किया।
second.
उनको ये बताइए लाइफ के साथ सब चीज छूटने ही वाला है।
जी, no, I know, Raju, he could hardly manage, but I made it a point that at any cost I'll appear on the
You just tell him.
Yes.
आप लाइफ टाइम
Raju,
तक
if
ही
they
तो
give an
बोलेंगे
offer,
ना
if they
नहीं।
give an offer,
You
Raju, I
call
think-
Mr. Let Mr. Indrajit
5
Sinha
minutes,
come.
I would say.
Let us figure it out. What
Yes.
is the exact? You tell us what is the exact
Raju,
amount.
The execution case, they have, it is 2 lakh and not rupees
2
with all
lakh
interest.
28,000.
With all interest.
2 lakh
With all interest and
28,524.
Inclusive of everything.
वही है ना।
Yes, that is
जितना झगड़ा मत करिए भाई।
that you claim 2,28,524.
हाँ, वही है।
Separate.
2,28,000 है ना?
I'll just see.
लमसम बताइए।
नहीं पता।
Joint compromise petition file. He lives in Ranchi.
No, Dhanbad here. No, it is the principle of the.
That is the entire claim.
Total difference of it appears to be the. नहीं ये principal amount है, interest नहीं जोड़ा।
हाँ, interest नहीं।
हाँ, total principal amount is 2,28,000.
That I can say. That is.
और interest कितना दिया?
जो भी बैंक इंटरेस्ट है जो भी मिलेगा।
So he must have directed, no, for payment of interest.
Also, this is the calculation of the.
There is no direction for payment
There
of
is no
interest. बताइए। जितना जल्दी पैसा मिल जाए उतना अच्छा, रिमांड कर देंगे तो सब्स्टिट्यूशन फाइल करना।
नहीं रिमांड हाँ वो तो he also.
Please don't do that.
No, let
You
let
call.
them give an offer letter. I'll take talk to my client and call.
He's coming just. मिस्टर सिन्हा को एक चीज बोलिएगा, अगर रिमांड हो जाएगा तो इंटरेस्ट के साथ पेमेंट का ऑर्डर होगा तो क्या होगा, राइट? सो जितना हुआ है उतना देकर शांति रखिए, ठीक? कॉल
5 minutes.
Item 10, WPS 690 of 2023.
petitioner.
Lordship, if serial number 10, I pray before your Lordship on behalf of Mr. Ajay Kumar Singh. He is ill, Lordship. So I am glad to not put it, Lordship.
कब चाहिए?
अगला हफ्ता
Counsel for the parties are present.
Appearance is
Petitioner is seeking retrospective promotion with effect from December 2016 with all consequential benefits. It is the case of the petitioner that all the juniors to the petitioner in the gradation list have been granted promotion, but for the reasons unknown to the petitioner has not been granted such promotion. The petitioner has attained the age of superannuation, and it is the case of the petitioner that on account of promotion and revision of pay, he would be entitled for enhanced pension, gratuity, leave encashment and other retirement benefits. It is a counter.
Yes, I'll counter it. There are only 4 paragraphs.
Was his juniors granted promotion?
No, not a single. I have stated in my contract affidavit.
Counsel
And-
for the respondents has submitted that not even a single junior to the petitioner was granted promotion.
I have filed counter affidavit. In counter affidavit, I have stated no junior has been promoted.
यही लिखे,
नहीं ये काउंटर पढ़ के आप बुजुर्ग के सामने
तो यही हम लिखा रहे हैं. The learned counsel for the respondents has submitted that none of the juniors to the petitioner were granted promotion.
let me add first.
Just a moment, he is seeking adjournment, so he should know that on what ground it is being made. Yes.
I have no problem. But
आपसे पूछ रहे हैं, हिंदी में पूछे, बंगला में पूछे, किस भाषा में पूछे? पिटिशनर के किसी जूनियर को आपने प्रमोशन दिया है? नहीं दिया है ना? तो यही चीज़ हम आपके ऑर्डर में लिखाए हैं आपकी तरफ से. At this, counsel for the petitioner submits that this matter has to be argued by Mr. Ajay Kumar Singh, who is not well. He submits that the matter be posted in the next week. Okay? Post this case on next Wednesday in the supplementary cost list.
Lordship, one more prayer. Serial number 18, Lordship, to Mr. Ajay Kumar Singh.
आप सीरियल नंबर 18 के लिए वेट करें.
Yes, Lordship.
Item 11, WPS 1207 of 2023.
the issue in hall.
Counter has been filed.
Yes.
All the respondents have filed the counter affidavit.
No, madam, only the commercial tax department. Respondent number 3 and 5.
Who has not filed the counter affidavit?
Respondent number 4, madam.
Respondent number 3 and 5 has filed.
Yes.
Respondent number 4 has not filed. Do you file counter affidavit on behalf of respondent number 4 also?
Yes. Because respondent number 3 has stated that they have sought an opinion from the respondent number 4 and thereafter they have passed the petition.
And where is the document at page para number 21? Para 21, page 26. Where is this document?
The document is not available at this time moment, Lord.
You file it?
No, so far the other petitioner is concerned. The similar documents I have annexed the series of the annexes 8, annexes 7, annexes 6. The very limited issue involved in this case, Lord. Even in the matter of the Achilles Prasad, the matter travel up to the Honorable Supreme Court. The issues involved in the entire writ application slots is whether the after limited examinations, the appointment after limited examinations.
The learned counsel for the parties and present. Counsel for the respondent submit that a counter affidavit has been filed on behalf of respondent number 3 and 5.
Yes.
Counsel for the respondents is directed to seek instructions and file counter affidavit on behalf of respondent number 4 also. Let the needful be done by
After 4 weeks, I have the first.
by 16th of May. Rejoinder, if any, by 3rd of July, post on 10th of July.
Item 12, WPS 2149 of 2023 along with item 13 to 15.
Yes.
Yes, Your Lordship, in these four cases, Your Lordship, all are with regards to the promotion to the post of inspector on and from 2011-2022, on which date juniors to the petitioners, Your Lordship, have all been promoted. The first case, Your Lordship, that is 12 WPS 2149. The present petitioner, he was killed, Your Lordship, by the Naxalites. That we have also stated and substituted by incorporating the name of the wife, Your Lordship. And on the last date, Your Lordships have asked my learned friend that even if a punishment of censure is given, will that affect the promotion or not? That in the rejoinder we have categorically stated, Your Lordship, at paragraph 15 and 16.
Who is the junior who has been granted promotion?
Yes, Your Lordship, although they have stated and given the name of only one, we have categorically stated that there are about 20%, Your Lordship. Your Lordship, will please just have a look to paragraph number 7.
What was your serial number?
That my serial number, Your Lordship, is
153 perhaps.
and serial number 74, merit list number 636.
In page 22.
Now at page 3 of the rejoinder, that is the short gist, Your Lordship. Please just have a look to the rejoinder.
Yes.
And they have stated in their counter affidavit, Your Lordship, that one Sangeeta, whose name appears at serial number 647, that is below to that of petitioner, she has been given promotion. But I have stated at paragraph 7, the names of all those persons, Your Lordship, 28 in number, who have all been granted promotion and who are junior to the present petitioners.
You say the petitioner is seeking a mandamus. You consider his case for promotion.
It may be disposed of in the light of your ladyship, para 8 of the counter affidavit. Can you see? Your ladyship, the letter number 3463, dated 3/6/22. Your ladyship,
Para
got the copy of this. The department has arrived at the post of Inspector of Police, and upon the recommendation of the DG Selection Board, the candidate can be considered for grant of promotion, sir. From the Sub Inspector of Police, your ladyship.
So in the light of this circular, it has to be considered.
Yes, your ladyship, it can be considered in light of this circular, your ladyship, as the punishment of censure, and it was regarding due to this departmental proceeding, it was the promotion was pending, your ladyship. In light of that, now when the next the committee will be formed, they can be considered.
He is claiming retrospective promotion.
Yes.
He is claiming retrospective promotion. You place his case in the next DPC.
Yes, your ladyship.
That should be sufficient.
For being promoted on and from 2011.
I will say that your juniors have been promoted. That will be taken into consideration. He may not have any right to promotion, but if a junior has been promoted, then certainly he has got some right crystallizes in his favor. If there is no other legal impediment, we do not know what is the situation. His entire records will be scrutinized and seen.
This is serial number 12.
Just a moment, let me finish this. The learned counsel for the parties are present. This petition has been filed for the following relief. The counsel for the petitioner has submitted that the original writ petitioner, Mr. Amit Kumar Tiwari, expired while in service, and therefore his wife is now the petitioner. Prayer quote. The learned counsel submits that it is an admitted fact from the counter affidavit that junior to the petitioner has been promoted, although in the counter affidavit the name of only one person has been mentioned. He submits that in the rejoinder he has given the name of as many as 28
28
candidates,
persons.
28 persons who are all junior to the petitioner and have been promoted. He has further submitted that there is a punishment of censure, but the same will not come in the way of the promotion of the petitioner. The learned counsel appearing on behalf of the respondents has submitted that the petitioner is seeking a mandamus. The case of the petitioner for promotion can be placed in the next departmental promotion committee meeting, and every aspect of the matter will be considered as per applicable rules, guidelines, etc. That's it. Including the claim of the petitioner that his juniors have been promoted.
They were eligible here,
I think she submits that the juniors were promoted as they were eligible for promotion. After hearing the learned counsel for the parties and considering the fact that the petitioner is seeking a mandamus by stating that his juniors have been promoted and the petitioner has been left out. In the rejoinder, in the counter affidavit, it is an admitted fact that one of the juniors to the petitioner, namely Sangeeta, at serial number 647 has been promoted. But in the rejoinder, the petitioner has given a list of persons stating that as many as 28 persons junior to the petitioner has been promoted. Further considering the submissions of the respondents, this court is of the view that no useful purpose will be served by keeping the present petition pending, as the claim of promotion of the petitioner can be placed before the departmental promotion committee before the next meeting of the departmental promotion committee. Accordingly, this petition is disposed of. The respondent number, who will place it?
DGP, Your Lordship.
The respondent number 2. Respondent number 2?
Yes, Your Lordship.
The Director General of Inspector, Karmik.
Karmik.
Okay. The respondent number 2 is directed to do the needful so that the claim of promotion of the petitioner be placed before the meeting, before the next meeting in the selection board of the departmental promotion committee, whenever it is held.
Only to that effect, Your Lordship, his promotion may be considered on and from 2011-2012.
They will see everything. That is why I have recorded that you are claiming promotion from a retrospective date. The departmental promotion committee shall consider the claim of the petitioner in accordance with it. This petition is accordingly disposed of. और भी कोई है साथ में? Same story.
No, Your Lordship.
Serial number? 13.
No, 13 is
14 is same. 14 लाइए जरा बैठ. उसमें भी junior को promotion दी.
Yes, Your Lordship.
Junior, who is the junior who has been granted promotion?
इनका pending रखा गया था because his different proceeding was going on. 2020 and 23 final order has come. Now his name is
Exonerated?
no, punished.
Punished. What punishment?
No, Your Lordship.
One black mark and in appellate it was reduced and only warning was
That is censor.
No.
censor.
First, Your Lordship is taking item number 13.
2195.
2195. Please just have a look to my rejoinder, Your Lordship. Everything has been stated in detail. And in the counter affidavit, Your Lordship will please see.
In this case also, in view of annexure F, it may be disposed.
Annexure F.
F of my counter. all the candidate whose promotion was pending
Hmm.
on the ground of department proceeding on almost 21. All this matter, they have seeking instruction to give their promotion to the department. This letter has been given to the department.
So his case can also be placed in the next departmental promotion committee meeting.
Your Lordship, may please just have a look to what my learned friend is saying, annexure F of the counter affidavit. In this case, Your Lordship, the names are given. At serial number 9, the name of the present petitioner appears, Your Lordship.
Mukesh Kumar Chaudhary.
Mukesh Kumar Chaudhary. And just at 10, Your Lordship, Sunil Kumar Kuswar. And he has been granted promotion after the orders passed by this Honorable Court.
That's right. Now your case will also be considered.
Only to that effect, Your Lordship.
Only to that effect should be sufficient. That they are already in the process of considering your case. They will place it on in the next departmental promotion committee meeting.
And a date may be fixed, Your Lordship.
We can't fix the date of our departmental promotion committee.
No, that case for consideration.
On the
of-
next, whenever this meeting is held, it will be considered on that.
This letter was passed on 12/12/2023, Your Lordship.
Whenever next it is held, Mr. Tiwari, we cannot fix a date from here, can we?
This is not for the departmental promotion committee, Your Lordship. It is only for the respondent number 2 to consider and decide.
Your matter will not be placed before the
No,
departmental
because
promotion
they have
committee.
already been considered and the names were already in the panel to be promoted.
So necessary decision in terms of annexure F is to be taken within
Taken.
some time?
Yes, Your Lordship.
Mr. It has to go to the departmental promotion committee or follow-up orders is
It will
required?
go to again department promotion.
It will go to the DPC, no?
Because in first department promotion committee list where petitioner name was appeared, that list it was kept pending and his name was separated from that list. Therefore again,
लिखिए WPS number 2195 of 2023. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the juniors to the petitioner have already been granted promotion, but the petitioner has been left out. He submits that earlier one departmental proceeding was initiated against the petitioner, which has ultimately resulted in passing of an order of censure only. The learned counsel submits that now there is no impediment in taking up the matter of the petitioner for the purposes of promotion. Learned counsel for the respondents has submitted that the writ petition can be disposed of in the light of annexure F to the counter affidavit. He submits that in counter affidavit it has been mentioned that as on date again sanctioned strength of 610 police inspector, at present 513 inspectors are working and discharging their duties, and the police headquarters has written letter dated 12/12/2023 to the Home, Prison and Disaster Management Government of Jharkhand and sought appropriate guidelines for promotion to the post of Inspector of Police, which is still awaited. And once the guidelines are received, appropriate decision will be taken. He also submits that Police Headquarters Jharkhand, by letter dated 12/12/2023, sought necessary guidelines for grant of promotion to those cases which were kept in the category pending. In the meeting dated 2/5/2020 by the Director General Selection Board, and once the guidelines are received, the case of the petitioner can be taken up for promotion. At this, the learned counsel for the petitioner has referred to annexure F and has submitted that in the list, the name of the petitioner, in the list whose matter was kept pending, there are altogether 13 such candidates, and the name of the petitioner appears at serial number 9 and the person at serial number 10 has already been granted promotion. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the respondents have themselves stated that now the matter regarding promotion of the petitioner can be considered, but they are awaiting certain guidelines in pursuant to the aforesaid letters dated 12/12/2023. It appears that much time has elapsed since the issuance of letter dated 12/12/2023, but still the case of promotion of the petitioner has not been considered, and amongst the persons whose name appeared in the letter dated 12/12/2023, it has been stated by the petitioner that case of one other person, namely Sunil Kumar Kushwaha, has been taken and he has been granted promotion. In such circumstances, this court is of the considered view that the matter regarding promotion of the petitioner cannot be deferred for an indefinite period of time for want of necessary guidelines. The respondents are directed to expedite the matter and place the case of the petitioner for and take appropriate decision in connection with the petitioner not later than 4 months from the date of communication of the suit. 4 महीना में आप कर दीजिए, आपका जो भी मिलेगा. 6 months. As per your circular, twice meeting is to be held. 6 months में तो हो जाना चाहिए. जुलाई में होगा I think.
Because जून तक वो लोगों ने बोला कि कुछ हो नहीं सकता उसके बाद.
Okay, 6 months.
Only because of the fact your lordship persons junior to them, they are working as inspectors now. And they being the seniors, your lordship
That's
are
right.
working
We have given
under
some direction, they will do the next. Yes, this one. एक और है.
और दो है.
हाँ, 2 है, बताइए.
This is your lordship. Item 5 to item 13. This is a very sad case, your lordship, because of the fact that this petitioner, he was the sub-inspector of the year 1994. And since then, he has not been given a single promotion. And the persons, your lordship, who have been appointed as sub-inspectors in the year 2012, they are now all working as inspectors. So all those persons who are much junior to the present petitioner, your lordship, because of the fact that he was appointed as a sub-inspector in the year 1994. The persons who have been given promotion to the post of inspectors, they are of the year 2012.
Why your name was never considered?
No, it was considered, your lordship. It was considered, and there was a departmental proceeding as against me in the year 2017. And 2020, your lordship, there was a punishment. So whatever be the case, your lordship, this 2017, the occurrence, that can be considered only for 3 years. After 3 years, your lordship, he has to be considered for promotion, and his juniors have all been promoted.
What punishment has been imposed?
Yes, your lordship, that we have stated.
You were amongst those who was declared ineligible for promotion.
My name appears in the panel, your lordship.
No, they say in the counter affidavit that you were amongst those whose name was declared
Unfit because only of that pendency of that, your lordship.
Where is that endorsement?
That is. There was a major punishment inflicted upon him.
Therefore, you were declared to be not fit for promotion. Your case was not deferred.
No, your lordship, it is, your lordship will please see, as
Serial number?
Page serial 19, page 17, he was declared unfit. He was in the list of the candidates who were declared unfit. That is his own understanding.
he was declared unfit because, your lordship, on.
Sorry, serial number.
Serial 19, page 17,
Page 70, serial
19,
19.
Jitendra Kumar.
Yes. Jitendra Kumar Raman,
Yes, your
Brihad Saja Prabhavi, Attair Ayogi. You were declared unfit.
unfit, your lordship, because of the fact that I was given a punishment,
Major
major
punishment.
punishment. But that major punishment, your lordship, will only be applicable for 3 years.
I don't know. Show me some law.
Yes,
to
your
that
lordship, that is the law. And that we have also stated, please just have a look to our rejoinder also.
No, you just tell us where have you stated so in the writ petition, then we will see their reply. If you have stated something in rejoinder, then they will have to respond to that.
I have stated, your lordship.
Where is it mentioned in your writ petition? Then we will see their response to that.
Your lordship, that is there. This starts from, your lordship will please see.
You have taken it in your rejoinder, then
No, in the writ application.
Where is it?
also.
Where is it?
Please allow me to read.
Yes.
Firstly, your lordship may please just have a look to paragraph 8,
8.
that on and from 1994.
Yes.
That on and from 1994 till today, no promotion of any manner whatsoever has been given to the petitioner. Although persons juniors to the petitioners since 2012 have been promoted to the post of inspector. The persons who were appointed as sub-inspector in the year 2012, they have been promoted to the post of, and this process of promotion to the post of inspector from the post of sub-inspector of the police category continued till the year 2018 and also in the year 2020. In the year 2018, your lordship, he was also eligible because there was a departmental proceeding pending as against him. So that rule which I have just cited to your lordship, 726, that even if there is a departmental proceeding, his case has to be considered, kept in a seal cover, and thereafter on the result necessary action will be taken. That in spite of putting in more than 29 years of service in the services of the then state of Bihar, and after bifurcation of the unified state of Bihar in the Jharkhand police, and although the petitioner hails from the scheduled caste category, yet his case for being promoted to the post of inspector in the Jharkhand police has not been considered by the respondents. That the details of his posting thereafter, your lordship will please see paragraph 10. That the details of his posting on and from
Mr.
59.
Tiwari, I just want to know, where have you stated in your writ petition that the impact of any major punishment is only for a period of 3 years?
3 years.
Such that we can just calculate 3 years and then figure out whether the rigors of that particular punishment has gone.
That is in the rule itself.
No, in
I
the
will show
rejoinder
the-
you have stated, then they will have to
Yes,
respond
your
to
lordship.
it.
That the
Then
details
let
of.
them respond then to that. Because we want their response. Merely by referring to the rule, we will not pass an order. We
Your
want
lordship will please
your-
allow me only to read what I have said.
Yes, yes.
Paragraph 10. The details of the departmental proceeding which as on today or on 2/6/2020 was not there is also reflected at column 11 of the service record, that is annexure 1. That although there has been a departmental proceeding initiated as against the present petitioner by the departmental proceeding number 158/2017, but the same was brought to an end by memo number 400 traffic dated 8/3/2020, wherein the charge levelled against the petitioner was found to be correct, but the learned superintendent of police traffic Ranchi was pleased to award a black mark for a special period which could not be applicable throughout the service career of the petitioner. This is, your lordship, annexure 4. And on the date of promotion, that as on today there is no departmental proceeding pending as against the petitioner, that the selection board by memo number such and such dated 2/6/2020 prepared a panel of 287 candidates who were to be considered for promotion to the post of inspector. However, the name of the petitioner did not appear in the said list. This I have stated, and that is my grievance, Your Lordship. Even if there is a black mark as against me, that is only applicable for 3 years, Your Lordship, according to the rule.
The learned counsel for the parties are present. The learned counsel, please hold on. I will ask you to file a supplementary affidavit. I can't decide like this. The learned counsel for the parties are present. The learned counsel, from the records of this case, it appears that the case of the petitioner was placed in departmental promotion committee meeting, and the petitioner was denied promotion on account of imposition of major punishment. The learned counsel submits that only a black mark was awarded as punishment to the petitioner, and the effect of the same expires. The effect of the same remains only for a period of 3 years. The period of 3 years has now expired. The learned counsel has referred to rule
726.1.
726.1. 726.1 and 726.3
3, Roman 3 of the police manual.
Of the police manual. The Roman 1 and Roman 3. Counsel for the respondents is directed to seek instruction and file a supplementary affidavit with regard to the aforesaid submission of the petitioner. You just do it in 1 week. It is very, very simple. You file an affidavit to that effect. Then only we can direct for consideration of this. 2 weeks. एक provision of law देखने के लिए 2 weeks. हाँ?
Because election duty में ना they are very that is the reason.
आप 94 से किसी बंदा को promotion नहीं दिए हैं.
We have
you don't need a supplementary affidavit. Just seek instructions and make a submission, right? Counsel for the respondents are directed to seek instructions with regard to the submissions made by the petitioner and advance their argument on the next day. Okay, that should be sufficient. Pose this case on next Wednesday.
Your Lordship, may please keep this one. This is the rule that will assist your Lordship. And the next case also, Your Lordship, one more case.
Yes.
Three, Your Lordship, may please see 3, Roman 3.
It appears to be quite clear, but still I will hear it on next day and then pass it.
Your Ladyship, the last case,
Yes, what?
CA15.
Yes. What is there in this case? उसको साथ में डालिए. Yes, Mr. Tiwari, what
Yes,
is there
Your
in
Lordship.
this case?
That the petitioner is entitled for promotion in the rank of Inspector of Police from the scheduled tribe quota, Your Lordship.
Why was he not granted promotion?
Your Ladyship,
Sunday.
because ACR was kept pending.
This is not fair. This is absolutely not fair.
The roster is in process, Your Ladyship. It will
You
be
can't
considered.
block a person like this. ACR will remain pending and you will not consider his case for promotion. Who is responsible for this? You can kill anybody like this. If somebody is not writing ACR, it's your duty. It is a duty of the department to ensure. Then you'll keep on promoting the juniors and keep his ACR pending. Fair enough? चलेगा?
Your Ladyship, and the roster is in process, Your Ladyship. It will be considered in the next, in light of that.
Where have you stated that ACR is pending and therefore his case was not considered? It must be there in the chart only.
Your
Sorry,
Ladyship, in para 8, page 8 of my counter affidavit.
It must be there in the list only.
That
list में कहाँ
the
है,
petitioner
Mr.
who
Tiwari?
featured-
Where is your name?
Yes, Your Lordship, it is there.
Where is it?
Please just have a look to their counter affidavit, Your Lordship.
Seniority list.
Page 17.
17?
Page 17 of their counter, Your Lordship, Annexure A.
Yes.
A serial number 32. Sanjay Chandra Uram. ACR is Aprapt.
Your Ladyship, I have already
And
mentioned.
junior-
For ST candidate, you behave like this. Right? You can do many things. You know that. You can't do this to ST candidate. Not at all. No. Not permissible under Constitution. Absolutely arbitrary. You can't do this. This we will not permit. Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner belongs to scheduled tribe category and the promotion of the and the case of promotion of the petitioner was placed before the departmental promotion committee but has remained pending on account of want of up-to-date annual confidential reports. The learned counsel submits that it is for the respondents to ensure that the annual confidential reports of each and every candidate is placed and the petitioner cannot suffer on account of non-action on the part of the respondents. The learned counsel has also submitted that many juniors to the petitioner has been promoted, but the petitioner has been deprived of promotion and the action of the respondents is especially arbitrary. The learned counsel for the petitioner has submitted that the case of promotion of the petitioner can be placed in the next departmental promotion committee and has no answer to the submissions made by the learned counsel for the petitioner. She has submitted that she is not aware, it is not clear from the counter affidavit as to why the ACRs of the petitioner has been kept pending. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that it is for the authorities to ensure that up-to-date ACRs are prepared and placed at the time of consideration of promotion. It appears that the petitioner has been deprived of promotion only for want of ACR, in which the petitioner has no role to play. Accordingly, the respondent number 2 is directed to take appropriate steps so that up-to-date ACR of the petitioner is made available prior to the next date of departmental promotion committee meeting and the case of the petitioner be placed on the next date of departmental promotion committee meeting with all the required documents for consideration of this case. This petition is disposed of with the aforesaid observation. Contempt nahi aana chahiye, please. Our constitution has special protection for them. We can't ignore it. Right?
That's
बहुत
taken
गलत,
in
बहुत
section
गलत.
about the cases that what can be done in petition.
You tell them. सारा ACR अपना collect करिए, आपका काम.
Your Lordship, only time may be framed because until
The
another-
needful will be done by the respondent not later than 6 months from today.
That's because they are working under the unions.
हो गया सब? ये किसका? बच्चा है क्या? Oh, yes, where is he? Mr. Vibhash Sinha, Mr. Indrajit Sinha was here. कोई बात नहीं, आने दीजिए, they'll come again. इसको pass over here. Lot of corrections pending, so I'll just rise.
At 2:50.